Courtroom deals can change in seconds, and today one defendant is about to learn that the hard way. From mental health defenses to shocking allegations that almost flipped a probation deal into prison time, this courtroom session has everything. Tension, last-minute twists, and judges making decisions that could change lives forever. Stay until the end because one interruption completely changes the direction of a sentencing, and the reaction in court says it all.
Good morning. Are you Erin Riley?
Yes, ma'am.
And this is 25 DCCR 1194. Ms. Riley's charged of assault of hospital personnel. And what is the announcement?
Your Honor, if we could have a little bit more time, Ms. Riley did provide me some documentation regarding her mental health status.
Okay.
This revolved around, that's why she was at the hospital that day, and I provided that documentation to the prosecutor. So we get some time to review that.
Sure. Any issues? All right. I'll just do a normal reset. Ms. Riley, make sure you stay in touch with Ms. Holmes and she'll let you know what she discusses with Mr. Smith and then when your next date is. Okay.
Okay.
You're free to go. And then, Ms. Holmes, you've got Kaylin Thornton sentencing.
Yes, ma'am.
This is Mr. Coleman's on Kaylin Thornton. Good morning, sir. You're Kaylin Thornton. And Mr. Thornton was previously in court in cause number 26 DCCR 0220, entered a plea of guilty to the third-degree felony offense of promotion of prostitution. I have received the pre-sentence report and reviewed it. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
The only correction, Mr. Thornton is working now. He
Good.
works for IHOP and at Main Event.
Okay,
So I know he said he was unemployed, but he is working.
good. Good. Anything else?
Based on the PSI and the lack of criminal history, I know the agreement was for a straight probation. We were inquiring as to whether the court would consider deferred.
Mr. Smith?
Judge, this is my case, but I would defer to your.
I mean, I typically, especially for job purposes, depending on the nature of the offense, give that opportunity on a first. We've got no misdemeanor, no juvenile, no felony. It would make sense to me. Any issue?
I don't have an issue with it.
Okay.
Mr. Coleman might get mad at both of us, but
Well,
he's not here.
I can handle it. All right, sir. What I'm going to do then, based on that discussion, is modify this to a 10 deferred. All right. Anything else then before I go forward with sentencing?
He has a GPS monitor on. He's been having it on for quite some time.
And that was a bond condition, so
Yeah.
that would be, I think, I won't require that unless there's some issues with probation. So he'll be able to get that off later today or tomorrow. And as long as everything else is going well, that shouldn't be an issue. I'll go through with all the conditions and make sure that's all understood. All right. Okay. So Mr. Thornton, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for a period of 10 years. There's Mr. Coleman.
As I was watching upstairs,
Go
I
ahead.
asked that the court reconsider, Judge. This initially there was an allegation of violence. I don't know if the court would want to put this on a brief hold so that we can maybe take a look at the PC affidavit. I can also give you a summary. But not only was there an aggravated promotion of, excuse me, I'm out of breath because
No, take your time.
Stairs down.
That's okay.
Not only was there an allegation that started out as a first degree aggravated promotion of prostitution that we have agreed to plead down to a lesser, but there was also an allegation that the individual or individuals who this defendant was essentially pimping were assaulted by this defendant, Judge. And I think under those circumstances, he's not. I think deferred would not be appropriate in this case.
So let me do this. Thank you for coming down, Mr. Smith. Mr. Coleman, give me just a second. I'm going to take a look at that.
And I would say that is an allegation. I'm not sure if Mr. Coleman has actually spoken with the alleged complainant. She's incarcerated, so maybe he could, or she was incarcerated as of last week.
Happy to have a sentencing hearing if the court
But
goes.
like I stated, for the reasons, there have been several types of cases where the court for even, I would say worse offenses than this, where a person has had the opportunity with deferred probation when they do not have any prior criminal history. So we believe that that would be fair in this situation.
Well, I mean, give me a second, because y'all did agree already, and
That's right, Judge.
that was what was offered, and it wasn't unagreed as to the type of probation. So give me just a minute. All right, I think I'm going to go along with that original deal. Thank you for coming down, Mr. Coleman.
Thank you.
Obviously, the allegations are very serious. So let me go back and do this. Mr. Thornton, you made an agreement for that 10-year term, and that's what we're going to go along with. And so I am, again, going to find sufficient evidence to find you guilty. I am at this time, in accordance with your agreement, going to find you guilty of promotion of prostitution. I'm going to sentence you in accordance with your agreement to a term of 10 years in prison, but that'll be probated. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That includes, you will initially be on the high medium caseload, which just means you'll be under a little more supervision so they can make sure you're headed in the right path. You will be required to complete the moral recognition therapy and pay the cost of that. Have absolutely no contact with Caitlin Whitsitt, and not be on the premises of 4150 Maida Road. In addition, no association or whatsoever with prostitutes in any way, whether they're willing or not. You cannot have anything to do with them. Do you understand?
Mhm.
If you do everything you're supposed to, you still have an excellent opportunity because you'll be able to serve that 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you'll be brought back into court and you'll be facing that 10-year sentence that you agreed to. Do you understand?
Mhm.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Thank you, Ms. Holmes. Thank you, Mr. Coleman. Good morning, sir. You Broderick Guillory? And Mr. Guillory, did you get someone hired?
I haven't got anyone hired yet. I
Speak up, please.
haven't got anyone hired yet, but I have, you told me to bring the names and my check stubs and my job, but I don't work there anymore. But I do have my check stubs and,
So why don't you work there anymore?
got laid off. The job ended, so.
Okay.
And I'm in the process of looking for another one now.
What lawyers should you talk to?
But, a guy named Ryan Kelly, Corey Crenshaw, and William Wilkerson.
Okay,
They all gave me different prices.
right.
Different payment plans, but I don't have any money to save it.
Okay, so I'm gonna have you fill out some paperwork this morning since you've done what I asked you to see if you qualify for a court-appointed lawyer. You need to fill that paperwork out accurately and completely because you're going to swear your oath that it's all true and correct, and then I'll take a look at it. If you step to the clerk on the end, she'll give you that paperwork. Good morning. Are you Rodney Hines? And Mr. Hines, this is your initial appearance and cause number 26 DCCR 0198. You're charged with a second-degree felony offense of aggravated assault causing serious bodily injury from November 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I haven't came to a official agreement or anything yet.
All right, so I'm also looking at the rest of your indictment, which shows 6 prior felony offenses, which makes this obviously very serious. You need to try to get someone hired before that next court date. I'm going to reset you about 30 days to give you some time to hire someone. If you do get someone hired, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. You understand? All right, step in front of the clerk. She'll give you a reset notice. Good. Are you Christopher Hunt?
Yes, ma'am.
And Mr. Hunt, this is your initial appearance and cause number 25 DCCR 1766. You're charged with the third-degree felony offense of assault on a family member with previous conviction. That's from September 28th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I called a lawyer named Paul Parker. He said he was going to be here today.
So Mr. Parker probably will be here. He's appointed to represent you while you were in custody.
Yeah.
But once you bond out, I expect you to try to hire someone. It can be Mr. Parker. It can be
Yeah,
whoever
called
else.
him and he said he'd be here.
So are you going to hire him?
Yeah,
Okay.
that's the one I was going to hire.
So what I'm going to do then, Mr. Hunt, is I'm just going to reset your case, a normal reset, which is about 30 days.
Yes.
Give you some time to get Mr. Parker hired.
Okay.
If you do get him hired, bring the reset that you get today to him, and he'll tell you what to do.
Okay, because I had talked to him and he said he couldn't take any money until after today.
Okay, so just listen to what I'm saying.
Yes, ma'am.
Okay, so if you get him hired after today, just bring the reset notice to him, and he'll tell you what to do.
Okay.
If for some reason you're unable to hire him or that doesn't work out, then you need to talk to at least 3 other attorneys. Bring me those names and we'll discuss your option.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
Also, you do understand as a condition of your bond that you're to have no contact or communication at all with David LeBlanc. You understand?
Okay, he is my roommate, but he's in jail right now.
Okay, so you cannot have any contact or communication with him.
So when he gets out, let my mom's the landlord, just let him go, kick him out.
Either he leaves or you leave.
Okay.
I don't care how that takes place or where you're living. I'm not going to get involved in
I'll
that.
talk to my mom as soon as he
You
gets
just
out.
cannot have any communication or contact with him.
Yes, ma'am.
Okay, step in front of the clerk. She'll give you that reset notice. You're cleared as a bill?
Yes, ma'am.
And Miss Bill, were you able to get someone hired?
You know, but I did speak with different attorneys.
Who'd you talk to?
I talked to Nathan, I talked to Kimmler, the Birch Kelly, Jane, a lot of them.
Okay,
But everything I can't afford.
are you working?
No. I'm actually self-employed, but right now my vehicle is on.
Okay. Self-employed doing what?
Moving
Say it again?
left.
Oh, okay. All right, so I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk on the end, she'll give you that paperwork. You're Bryson Griseski?
Yes, ma'am.
And Mr. Griseski, this is your initial appearance and cause number 24, DCCR 1962. You're charged with the state jail felony offensive burglary of a building from June 27th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Ask for a court appointed.
So when you're in custody, we automatically give you a court-appointed lawyer. Once you bond out, though, I expect you to at least try to hire your own lawyer. So I'll reset your case about 30 days to give you some time to see if you can get someone hired.
Yes, ma'am.
If you do get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you've actually talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. You understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you that reset notice. Good morning. Are you Gilbert Robinson Jr.? And Mr. Robinson, this is your initial appearance in cause number 26 DCCR 0454. You're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation from December 11th of 2025. Since you made bond in your case, have you had an opportunity to try to hire a lawyer?
I have made attempts, yes, ma'am.
Okay, so what I'll do is reset your case about 30 days to give you some more time to see if you can get someone hired.
They're just expensive.
I know, that's what, save up some money and do your best to try to get someone hired before that next court date. If you do get someone hired before the next court date, then bring that reset notice that you get today to the lawyer and they'll tell you what to do.
Great.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers.
That's not a problem.
They all charge different amounts, different payment plans. Bring me back the names of the ones you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising a bond and you'll go back to jail.
I don't want to go to jail.
Also, you know that part of your bond is to have no contact whatsoever with Deandra Flores, correct?
What about my daughter? I don't understand.
Well, so is that your child's mother?
Yes.
So you need to have a third party. You either need to get started with something in family court or through the attorney general to get custody set up. Or you need to have a family member or third party help you with the communication, pick up, drop off. There's no order that you not have contact with your child, as far as I can tell, but you have to get someone else to help facilitate that.
I could get my mom to contact her.
Sure.
To
Just about visitation of the child, not about any other, don't send any other messages or anything like that. But yes, with regard to your child, to find out what's going on with her or get visitation, yes, you can use your mom. Okay. Step in front of the clerk. She'll give you a reset notice. Good morning, sir. Are you Justin Eddins?
Yes, ma'am.
And this is 26 DCCR 0136. Mr. Eddins is charged with making a false statement for property or credit.
Judge, I think both sides are requesting a bit more time in this case. We've got an alter that we're talking about. Also communications, the feds are involved on part of this and not on this. So just trying to clear everything up.
Sure. All right, we'll do just a normal reset, give y'all time to see what you can get worked out, and then we'll see where we are at the next court date.
Thank you, Judge.
Yes, sir. Take care.
Thank you, Judge.
You're free to go. Good morning, ma'am. You're Kayla Provost. And this is 25 DCCR 0972. Ms. Provost is charged with evading arrest or detention with the use of a vehicle. I reset this last time to give you guys an opportunity to review that video. Were you able to review the video with your attorney? Speak up, please. And what is the announcement, Mr. Adams?
we know, please.
Oh, I'm sorry. It just came through. It wasn't there when I called you and then it popped up. And will she waive the formal reading of the indictment?
Yes.
All right, let's start over then. And Ms. Provost, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Adams? Speak up.
Yes, ma'am.
Thank you. And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation? Y'all did the wrong paperwork. Y'all did state jail felony. Yeah, I've got to delete that. Y'all got to do the right paperwork because it has the correct admonishments on it. All right. We'll start over in a minute. Y'all get that done on the TDC, please. Paperwork. Good morning. Are you Kingston Walker?
Yes, ma'am.
And Mr. Walker is here in 2 cases. We've got clause number 25 DCCR 0861. Sorry. Charged with the third-degree felony offense of tampering or fabricating physical evidence, and that's from March 27th of 2025. And then in cause number And what that means, sir, in that case, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And then in clause number 2025 DCCR 0862, you're charged with a third-degree felony offense, the possession of a prohibited weapon, and that's from March 27th of 2025. And also, that means if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them. They show, they're called plea bargain rejections, and it shows that the district attorney's office has made offer if you wanted to enter pleas of guilty in your cases for 8-year terms in prison on each case, and that would be to run concurrently. Is that correct?
Yes, ma'am.
Right. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter pleas of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Is there any evidence or discovery that you guys don't have?
Judge, I'm looking at Mr. Coleman's notes. It looks like discovery's been provided. I believe.
Okay,
I think they're
Probably, it's not going to stop.
okay. All right, then we will move it to the trial docket. Stay in touch with Mr. Burbank. He'll let you know when you need to be back and ready for trial.
May be excused to that.
Yes, sir. And then you've got Jaden Chandler.
I wasn't in there.
Jaden Chandler.
All right.
I've been talking to Tom about it.
Good morning, sir. Are you Jaden Chandler?
Yes, ma'am.
And this is 25 DCCR 1481. Mr. Chandler is charged with engaging in organized criminal activity. Mr. Burbank?
Your Honor, we have a plea agreement, which we were going to accept. But when my client showed up today, I would like it reset a week, please, so that he may come up back in front of this court. Maybe a little more appropriately dressed.
Why would you show up like that?
Well, he is working 7 days a week, 14 hours a day, trying to get his life back together again.
I mean, he's here now in front of me. Y'all don't want to just do the paperwork?
Would you want to do that? I mean, I don't want to. I can. And then set it for PSI maybe?
Where are you working?
XL Pro Construction, or it's Panther Construction, but it's a staffing company called XL Pro. It's out there by the landfill.
He's had a operation on his hand. He almost lost his hand. It's up to you, Judge, which one.
No, I mean, if y'all have an agreement, I mean, he's already in front of me, so you might as well
Okay.
get it taken care of today. We can get
Reset it.
this started. I'll hold it.
Take care of it.
Okay.
Cool. We'll back to
All right, let's pick up where we left off, Ms. Provost. In clause number 25 DCCR 0972, you already entered that plea of guilty to evading arrest or detention with the use of a vehicle. I have in front of me on the tablet some documents, again, that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, sir.
And again, that agreement is for a 4-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Ms. Provost is not competent?
None.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today to start that process, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Here you go.
Thanks, sir.
Thank you. We good.
Good morning, good. You're Catherine Batista. And this is cause number 25 DCCR 1608. Ms. Batista's charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Your Honor, if we could have 30 days to plead this case. I've received an offer from Luke this morning.
also have received all the discovery, and I'm quite certain, I'm convinced the case is going to work out. And I've relayed the offer to my client already.
All right, so I'll just do a normal reset, Ms. Batista. Make sure you visit with Mr. Paget before that next court date, so you know what you want to do, and we'll take care of it on that court date. Okay, you're free to go.
Excellent.
Yes, sir.
And then you've got a sentencing on Kenneth Spears.
We're ready to go.
One thing this courtroom proved today: in the justice system, every word matters, and every decision comes with consequences. Some defendants walked away with second chances, while others got a brutal reminder that probation is not freedom, it's a warning shot. Which case shocked you the most? And do you think the judge made the right calls? Drop your thoughts in the comments, because this courtroom debate is far from over.